Hi, I'm Allie Jackson Jolly. I'm here with Kevin Goldberg. He is an attorney. He is also a First Amendment specialist with the Freedom Forum. Kevin, welcome and thanks for being here with us.
Thanks for having me.
Yeah, so it has been quite a day at the United States Supreme Court, especially for anybody who follows the First Amendment or social media. Of course, I'm talking about the fact that the justices heard several cases that pertain to laws coming out of Florida and Texas that seek to understand regulation of social media. So first, let me ask you, what do you think we should know about this case or these cases?
Well, these are two cases, each involving a separate state law. So one was Florida Bill 7072, and one was Texas House Bill 20. They were both passed way back in 2021, and only now are getting their day at the Supreme Court. But they each kind of do the same thing. They tell social media platforms that they have to carry certain speakers or posts. Even if the platforms don't want to, even if the speakers or the posts violate the platform's own terms of service. They do this in slightly different ways. The Florida bill prohibits social media platforms from barring political candidates or journalistic enterprises, or deleting or minimizing the visibility of posts by or about them. They do a few other things as well, saying social media platforms can't change their own terms of services more than once every 30 days, and say the platforms have to allow users to opt out of algorithms that prioritize certain content, essentially saying that I as a user could say, I only want a chronological feed, not something that is kind of fed to me in different ways. The Texas bill is sort of similar, but it actually prevents platforms from censoring posts or preventing users from seeing content based on that user's viewpoint. So it kind of looks more straight politically at what the content is and says you have to treat all content the same. It also requires platforms to tell users anytime a post has been removed and explain why. They both apply to large social media platforms only. The Florida one looks at platforms that have more than 100 million monthly users or $100 million in gross revenue. And the Texas one looks at platforms that have more than 50 million active users in a given month. But we're really talking about they look primarily at the biggest sites, the Facebooks, Instagram, YouTube, X, formerly Twitter, but not the smaller platforms like Rumble, Parler, and Truth Social. There's a lot of discussion at the court today about what would be included, what wouldn't be included, but that's the basis. Is the basics are that large social media platforms would have to accept all posts and all users, and couldn't kick any of them off or delete posts.
Yeah, and so, a lot of the experts who've been watching this have been saying, this has been a long time coming. I think I hear terms like social media wars, and that by June, many believe that we will have a completely different landscape. Do you believe that's the case? Do you think things will look much, much different with respect to social media by June, say, of 2024?
I think that potential was there, but I don't think it's going to happen. Based on what we heard today at the court, it really looks like a majority of the justices did not want to interfere with and I'll call them this, editorial decision making, the curation activities, the content moderation that these privately owned social media platforms currently enjoy. And I think they understand that these, again, a majority, I would say even as many as six, really are understand and are committed to the fact that these are private businesses that get to make their own decisions. I think there's probably three, maybe a fourth, that would be willing to intrude on that. And if there were more, if there were a majority that took that viewpoint, then yes, the Supreme Court would be upending social media as we know it. That potential still exists. I just don't think it happens based on what I heard today.
Yeah, and so I've got to ask, which justices do you think are those three, maybe four that will be in the minority? Which justices do you think are willing to take a heavier hand around this kind of stuff?
I think they would be Justices Clarence Thomas and Samuel Alito for sure. I think Justice Neil Gorsuch leaned that way. And interestingly, there were some hints from Ketanji Brown Jackson as well that she was kind of wondering about how we could create a better internet. I don't think she gets there, though. I really do think ultimately it's a 6-3 kind of split amongst the court between the six that don't want to intrude on the private businesses that these social media companies are, and understand they have their own First Amendment rights to curate their sites, to moderate the content as they want to, similar to a newspaper, frankly, similar to a television station, similar to any other private business that wants to let people come in the door and keep other people out. And then you've got those others. You have Thomas, Alito, and maybe Gorsuch, probably Gorsuch, who might lean the other way.
Yeah, and so how about, were there any big moments that made you gasp today? Were there any big surprises that sort of took you off guard, or that you think that those who didn't watch all, what did you tell me, 5.5 hours? How long did this go on for?
It went on not that long, thankfully, because I did listen to all of it. I had it clocked at about 3 hours, 15 minutes, which I mean is still long enough to run a marathon. Not long enough for me to run a marathon, by the way, but long enough for some people to run a marathon. And that's going to give you some perspective as to how long the justices were there, thinking, speaking, considering, questioning, and how long a couple of the attorneys were there. I mean, Paul Clement was an attorney that represented the coalition of internet companies represented by a trade association known as NetChoice and the CCIA, and argued against both laws. I mean, it was a lot of mental energy expended. In terms of like wow moments, I didn't didn't have one. But what really surprised me was kind of how much the justices entertained whether these laws are facially unconstitutional or not. And this gets into a sort of a technical area we can talk about more if you'd like. But really, I was really set for them to strike these laws down like that, and that may not happen. It may be that we come back to the court again for something like that. But so that was a little surprising to me that they weren't ready to just sweep these right off the board as unconstitutional.
So the social media wars continue then. Your prediction is that this is going to go on a little longer than maybe some had expected.
Well, I think that possibility exists. It definitely seems to me, as I said already, that there are about 6 justices who are certainly siding with the social media platform, but maybe those 6 don't agree exactly procedurally on how to deal with this case, like what to do procedurally in terms of answering the question, because they really don't want to strike this law down as completely unconstitutional in all ways. So they don't want to uphold what we call a facial challenge to the law. And what that means is that they're going to perhaps, keep the injunction in place that keeps the laws from being active right now, from being enforceable right now, but send them both back to their respective states to build a bigger factual record on which they can say, oh yeah, these are completely unconstitutional no matter how you slice them, no matter how you look at them, no matter how you apply them. There's just no way that any part of them is constitutional. And yeah, we're going to sweep them off the books entirely. Or they may say, no, there are plainly constitutional aspects to these, so we can't entertain a facial challenge. And what we have to do is then have individual sites come back and say, well, this is unconstitutional as applied to me, what we call an as applied challenge. And they're going to say, okay, yeah. And it becomes a bit more piecemeal. So I think we're going to have to wait and see until June how they dispose of the case. I do think they're going to, again, say the laws are not enforceable right now either way, probably send them back to the lower, possibly send them back to the lower courts, I should say, for a building of a bigger record, and then, come back and deal with this perhaps in a couple of years. But I don't think they're just going to say the laws are constitutional and can go into effect right now. That I really do not think will happen, because there were a majority of the justices who seem that sympathetic to the state's arguments in light of the First Amendment concerns.
All right. Well, I am certain of one thing, and that is that the conversation is going to keep going, because regardless of what happens with these set of cases, we do know that in March, the Supreme Court is set to hear another series of cases that pertain to social media and First Amendment. So before we leave, because we are almost out of time, would you just give us a little preview? Let us know in March, what are those cases and what should we be looking out for?
Right. So I think we're going to play this out to the end of the Supreme Court term, right? Because we're probably not going to have any opinion in these two net choice cases argued today until June, and you will, as you said, get to enjoy more on this subject in March in the case of Murphy versus Missouri, which deals with how much a government employee, a government agency, the government at large, can interact with social media platforms to try to get them to voluntarily take down content that the government believes is potentially dangerous, or either because it's dangerous content, it's misinforming the public, it's intentionally misinforming the public, what we might call, some people might refer to as disinformation. And so that kind of interlocks with this case as well, because it's all about the autonomy that the social media websites have to curate and moderate their own content. And by the way, I'll add in that we have already heard a social media related case back in two of them in October, which dealt with when public officials can block constituents from following them on interacting with them on social media. So it's a big social media First Amendment heavy term. We've been writing about this and following all the cases on our website. And I would love the opportunity to come back and talk to you about that when those cases are both argued and all these cases are decided, and maybe make sense of it all, not just individually, but how they fit together.
Yeah, let's do it. I promise you it's a date. I really appreciate you coming, making us a little bit smarter about all this stuff, and we'll talk to you sometime in March.
Look forward to it. Thanks so much.